Give us a sense, as far as we know, it hasn't been specified by the president, what exactly might be taken up. I must say the Supreme Court's already had a couple of peaks, right, at North Carolina and at Pennsylvania.
Yeah, absolutely. They've been looking at a number of cases that have cropped up before Election Day about procedures to voting and receipt of ballots and things like that. So the question really turns on whether or not there's a legal hook in any of these states where I think it's close enough to maybe alter the outcome of the election to file a challenge or to initiate a proceeding. There are some proceedings, like in Pennsylvania, that have already gone up before the Supreme Court and are still pending before them, potentially for later resolution. But the question is whether there's a fresh batch of legal challenges that can be initiated at some district court at some point in the near future.
So this is, I think, a very important point. As you say, the Pennsylvania situation has been up in front of the court. Some people are saying this court didn't take the case or ruled in the case. In fact, it was an emergency stay, right? There is pending, I think, a cert petition still on the merits. The Supreme Court still could come back and decide that case on the merits.
That's right. So a merits hearing is where both sides have had the opportunity for sort of full briefing. You go up for oral argument. So when we talk about Bush versus Gore happening in 2000, there was a very compressed time frame where they did it in a matter of days. They were able to sort of do this work. But right now, you're right. Before the election in Pennsylvania, it was this sort of emergency status to say when the Pennsylvania State Supreme Court said under the state constitution ballots needed to be accepted up until 3 days after Election Day, as long as they were postmarked by Election Day, or including those ballots that didn't have a postmark received in those 3 days after Election Day. And the state officials said, well, what we're going to do is segregate those ballots. We're going to set them off to the side. We're still going to count them, but in the event that there's a future legal challenge, as the Supreme Court suggested is still before them, we're going to have this evidence in case there's a question about that. So if we're talking about a very sort of specific challenge to Pennsylvania, it would be that batch of ballots that comes in Wednesday, Thursday, Friday, and then we'll see if there's any sort of, if that's determinative and if there's going to be litigation up before the Supreme Court to continue to press it.
So, Professor, as best I recall, the Supreme Court is not usually in the business of deciding state law. It decides federal law, particularly federal constitutional law. In what circumstance might it make sense for the Supreme Court to overrule the state Supreme Court in Pennsylvania, which, as I understand it, was interpreting the state constitution, wasn't it?
Yes. So this is a really tricky area of the law and certainly a controversial one. It came up in Bush versus Gore, and actually before that, a case called Bush versus Palm Beach Canvassing Board that says, as a general matter, federal courts defer to state interpretations of state law, but sometimes when it involves sort of federal interests, we don't do so. We give them some deference, but we ensure that they're not sort of engaged in arbitrary practices of sort of remaking legislative preferences. And part of that really turns on this notion that Article 2 of the Constitution gives to state legislatures the power to set the rules for presidential elections. And squarely in Pennsylvania law, and even the Pennsylvania Supreme Court said this, ballots are supposed to be received on or before Election Day. But the Pennsylvania Supreme Court said, well, under our free and fair elections clause, which is a pretty broad phrase, we construe that phrase to mean that we can accept these ballots up until 3 days after Election Day. And so at least the hints of some of the theory that's been floated up before the Supreme Court so far is, does this go too far in construing sort of essentially the state constitution to overturn the preferences of the state legislature? Again, it's controversial. It cropped up a little bit in Bush versus Gore, and we'll see if there's interest in the Supreme Court to revisit that issue.
Professor, give us a sense of that compressed time horizon. As you said, in Bush versus Gore, it was very compressed. It's not just, as I understand it, the swearing of the next president, which is specified in the Constitution for January, but also there's the meeting Electoral College. I think that was part of the impetus for the Supreme Court last time around. That was why we had an early December deadline.
That's right. So this year, the presidential electors meet December 14th. That's really the drop-dead date. Before that is a date called the safe harbor deadline on December 8th, where Congress has sort of indicated a preference for states to resolve their disputes. And actually, that safe harbor deadline was really important in Bush versus Gore because the Florida Supreme Court found there was a legislative intent to take advantage and resolve everything by that safe harbor deadline. That was one thing the Supreme Court sort of attached to say the counting needed to stop. So when we're looking at deadlines, Pennsylvania's and some of these states, they're going to get these results. There'll be opportunities to file for recounts probably starting next week if it's particularly narrow and if the statutes authorize you to do so within 0.5%, 1%, depending on the states. And then, the goal will be to expedite either that or any other legal challenges, recount or otherwise, before December 8th, but certainly before December 14th.
Okay, so here's an unfair question. The Supreme Court decided in Bush versus Gore. Do you have an impression of the court and whether it thought it covered itself in glory back 20 years ago, that it'd like to repeat that, as opposed to let's keep our mitts off of it, because it didn't really do us very well, at least in public perception last time?
Yeah, there are a few people who have litigated Bush versus Gore who are now on the Supreme Court, but only a couple of members who served on the court during Bush versus Gore, Justices Thomas and Breyer. Justice Breyer dissenting in that case and has expressed, some, in that opinion, regret in sort of the court stepping in. Justice Sandra Day O'Connor, who's since retired, sort of expressed some concerns as well. So I do think, to the extent that there's some institutional awareness, and maybe Chief Justice Roberts is particularly aware about that, I do think the Supreme Court might be reluctant to the extent that it's going to be decisive. Now, to the extent it's a case that doesn't change the outcome of the election, maybe they feel more comfortable weighing in where it's a little bit cooler, it's not as significant a decision. But to the extent it might turn the presidential election, I do think there might be a little bit more hesitation.